Good evening, everyone. My name is Holli Packer, and I am both a Tulane 2L, so second-year law student, and I'm also a U.S. Coast Guard veteran. Now, today I'm going to be presenting on the case Air and Liquid Systems v. DeVries, and I was particularly interested in this case because it does deal with military compensation. Now, in this case, the Supreme Court established a new duty to warn standard for maritime products liability, specifically as it relates to incorporated products. To give you a little background about this case, two U.S. Navy veterans were exposed to asbestos during their time in the Navy, and unable to sue the Navy due to their immunity, they sued the equipment manufacturers, alleging that they developed cancer due to the manufacturer's products and that those same manufacturers were negligent in their failure to warn. Now, the manufacturers argued that they should not be liable for the harms caused because it was the subsequent third parties' parts, including asbestos, that caused the harm to these Navy vets. And this is commonly known as the bare metal defense. Now, the Third Circuit on appeal held for the Navy veterans adopting a foreseeability approach, as they outlined that the manufacturers could be held liable when it is foreseeable that the product would be used with another product or part, even if the manufacturer's product did not require the use or incorporation of that product or part. Now, the Supreme Court ultimately rejects both of these standards and adopts a third approach, where they specifically say, and I quote, "A product manufacturer has a duty to warn when, 1, its product requires incorporation of a part, 2, when the manufacturer knows or has a reason to know that this integrated product is likely to be dangerous for its intended use, and 3, the manufacturer has no reason to believe that the product's users will realize this danger." Now, in my analysis, I'm critical of the Supreme Court because they ultimately make up this new standard rather than addressing the real issue, which is the Perez doctrine. Now, in 1950, the U.S. Supreme Court held that members of the armed forces cannot recover from their active duty damages under the Federal Tort Claims Act. So what that means is if a military member is harmed, they're forced to seek relief through other means rather than suing, in this case, the Navy directly. Now, a little over 6 months after this DeVries hearing, so the DeVries hearing happened in October of 2018, in May of 2019, the Supreme Court decided not to grant cert to a case that challenged the Perez doctrine directly, and this particularly dealt with medical malpractice. And in that denial of cert of that case, Justice Thomas, in dissenting the denial of cert, alleged that the court's decision in DeVries, so in this case, I quote, "twisted traditional tort principles to afford them the possibility of relief, and that the denial of relief to military personnel and distortions of other areas of law to compensate causes a ripple through our jurisprudence as long as the court refuses to reconsider Perez." So ultimately, the Supreme Court came up with this standard other than taking a look at the true issue, which is how military veterans are compensated. Now, also from a practicality standpoint, this standard leaves a number of issues and questions that are going to need to be litigated in lower courts. So to this first element of the standard, this idea of requires incorporation. So for example, a 2-part paint, when you mix it together, is fully incorporated. It can no longer be separated. That could be an example of requires incorporation. Yet a turbo, which is added to an engine that can ultimately be separated, replaced, changed, altered, could also be considered incorporated in the sense that it's required to make the engine work. Again, the Supreme Court does not make the differentiation between requires incorporation, meaning cannot be separated, and requires incorporation, meaning that it can be interchanged or replaced in some way. To the second element, the idea of likely to be dangerous for its intended use. First, the term likely, again, is not defined. Does that mean 51%? Does that mean 80%, 90%? It's unclear. Second, what qualifies as dangerous? And then furthermore, what qualifies for dangerous for its intended use? So another example. If I'm using a sander and I'm using the appropriate protective equipment, meaning a mask, goggles, that particular sander likely does not cause me a good amount of damage. There's a level of safety precaution there. But if I decide to use a sander on the side of the boat without any of those protections, that would possibly lead to a different level of danger. So again, the Supreme Court does not establish what standard of dangerous or what is required to fall within this second point to their standard. And finally, their third point, the idea that there's no reason to believe that a product will realize this danger. In the current day military, Coast Guard members, Navy members go through a number of trainings. Some individuals are more trained than others. Some have particular specialties. When it comes to determining whether or not the products or individual will realize this danger, the Supreme Court does not establish what level of knowledge that individual has to have. So are we talking about an individual off the street, an individual who's gone to training for 3 years? Again, it is unclear. And finally, the Supreme Court does not even acknowledge the idea of the sophisticated user defense. Now, under the sophisticated user defense, if the product manufacturer can determine that the individual who was using the product had some sort of higher knowledge, training, or should have known that what he or she was doing was dangerous, there is a defense, a sophisticated user defense that will ultimately not make them liable. The Supreme Court does not mention this defense at all. So how the sophisticated user defense will be ultimately brought into this standard is again unclear and for the lower courts to decide. So ultimately, in attempting to establish a middle ground between the bare metal defense and this foreseeability standard, the US Supreme Court established a precedent that only creates more questions than answers. Other federal courts will have to refine this standard in its further applications. Thank you.